Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court. Please be seated.
Good morning, ladies and gentlemen, and welcome to the February docket of the Tennessee Supreme Court here in Nashville. We also welcome those of you that are joining us by live stream. We're glad you're able to do so too. We have three cases on our docket here this morning. We will hear the first case, and as a part of that, we want to say a special welcome to former and now Special Justice Roger Page, and we appreciate him joining us as a result of Justice Wagner needing to recuse in this case. So he has joined us. We very much appreciate him being willing to do that. We'll have that. We will then take a recess after the first case, and we'll come back and then hear the other two cases as well. So with that, I think we're ready to proceed. I would remind, if you are the appellant, if you wish to reserve time for rebuttal, please do so when you come up. Each side will have 30 minutes. Mr. Clerk, we have any preliminary matters?
No, Your Honor.
All right, call the first case, please.
Metropolitan Government of Nashville and Davidson County et al. Versus Bill Lee et al.
Good morning. I'd like to reserve 7 minutes for rebuttal.
All right.
May it please the court, Allison Bussell for the appellant Metro Nashville. In 2023, the General Assembly passed 4 laws targeting Metro Nashville. 2 of those are before you today. A third is the subject of a lawsuit that was stayed pending the outcome of the airport authority case. And in the 4th, the law was stricken by a 3-judge panel as unconstitutional local legislation, and the state did not appeal. But the common thread in all of those laws is the chipping away of local sovereignty through crafty drafting. The drafting strategy for the law at issue here, Public Chapter 21, presents new and interesting constitutional issues. But the rules of statutory interpretation and constitutional interpretation that govern those issues are not new. And this court's precedents that apply to those issues are not new. But the state, in all of its briefing, has a common thread. Ignore that language in the statute, in the constitutional text, and in those precedents. Why? Because you can't save this act if you don't. But that will come with a cost. In this case, it's the expense of local sovereignty. But in the next case, you will have established precedent that words don't matter, and exceptions can always be expanded to achieve a particular outcome. You should decline that invitation.
Ms. Bussell, what language do you contend that the state is asking us to ignore? What language in the act do you contend makes this local in either form or effect?
Well, I would like to answer the question more broadly, and then I can narrow the answer down to the local legislation clause argument. The state is actually asking the court to ignore language both in the constitutional text and in the act. So in the constitutional text, the state is asking the court to ignore the exemption clause and portions of the exemption clause. Turning to the local legislation clause claim, the state is asking the court to ignore the qualifying language in 1A, which sets a statewide cap on the size of metro councils as further provided in this section. Now, the state is villainizing Metro Nashville's argument about the text, framing it as a heads-I win, tells-you-lose proposition. But this is really just another iteration of the state's outcome-driven theme.
Ms. Bussell,
yes.
let's focus for a minute. I mean, you can say that the state wants to ignore, but the question we have before us is the interpretation of those provisions. So saying somebody wants to ignore or something like that is really not productive for us. Let's focus on what is the proper interpretation of those provisions.
Yes, Your Honor, but respectfully, part of the court's role when it is conducting statutory interpretation is to give all of the words in the act meaning. And so if the phrase "as further provided in this section" is merely clarifying the same rule repeated 3 times, despite that rule being repeated differently in Section 2 as to non-compliant cities, then that is a necessary component of what the court is supposed to do. The court is not supposed to ignore language in a statute to the detriment of legislative intent. And if the intent of this law was simply to set a statewide cap in Section 1, then it would be phrased precisely the same way that statewide cap is phrased in Section 2. But that wasn't the intent. Section 1 sets that cap as provided further in this section, precisely so it can treat metropolitan governments differently than non-compliant cities. That is what makes this a Leach case and not a Burson case. And here's what I mean. In Leach v. Wayne County, this court examined Section 8 of the Enabling Act that followed the 1978 county restructuring amendments. The law that the court was looking at gave boards of commissioners the right to decide whether each office in multi-member districts had to be separately designated on the ballot. But in Wayne County and Bledsoe County, it had to be separately designated on the ballot. In other words, the law set a statewide rule, but gave 2 counties fewer choices. So true here. And in Leach v. Wayne County, the court found that those differing provisions for those 2 counties was unconstitutional local legislation.
Well, but here, Metro Nashville is simply differently situated. I mean, you have B1 that deals with implementation where the membership of the council must be reduced at the time of the statute's enactment. And then it goes on to, establish implementation for councils that are that come along later. And so it's treating, with respect to the actual kind of regulation, which is the council size, right? Everyone's treated the same. You can't have a council, over that size, that cap. So the only way in which they're really treated differently and where you have different provisions applying is as to how they are actually situated, whether they exceed the cap at the time of enactment. I mean, why isn't that permissible to kind of treat them differently with respect to implementation? Why isn't that just like the transition provisions that we have upheld in our past cases?
2 reasons. 1, Section 2 doesn't do that, right? So the key here is Section 2 doesn't treat non-compliant cities that way. Section 1 and Section 2 treat non-compliant entities completely different. And we would submit that is because it was the legislature's intent to caveat Section 1's cap as further provided, right? So those provisions are not in Section 2. And the other reason this is not a transitional provision is because Leach v. Wayne County says it's not a transitional provision. And so to find in favor of the state or to adopt the Court of Appeals holding in that regard would require this court to overrule Leach. In Leach, the court explicitly said that those provisions that affected Wayne County and Bledsoe County, which by the way are in the very same provision of the act, these are not separate provisions. Those were deemed to be not transitional provisions because they did not flow from this sort of county restructuring scheme. And secondly, they were held to be unconstitutional local legislation. This is a Leach case, not a Burson case. We would also submit that the solution to poor drafting choices in legislation is an amendment, not wholesale court-ordered rewrites, which is effectively what the Court of Appeals ordered and what the state is requesting. The sponsor of the act seems to recognize this principle because he just proposed House Bill 2186, which appears to be a law about local option sales tax, but it also amends this act. And it would do 2 things. It would delete the very language that the state is asking you to ignore. It would delete as further provided in this section, and it would delete B1, B2, and B3, those local informer effect provisions that affect Metro Nashville. I don't know what will happen with that legislation, but it is a glowing endorsement of Metro Nashville's interpretation of this statute.
Ms. Bussell, do you agree that if we uphold this act as constitutional, that any other metro governments in the state will be limited to 20 council members, right?
I do, but the key there is that that's because 1A also applies through other provisions of the Act. Again, this actually supports our textual reading because it's 1A sets a cap as further provided in this section. Another section that we have not challenged is the section that would require future metropolitan governments to have a 20-member cap. Again, the key here is that it sets a rule, but then it treats non-compliant Metro Nashville differently than non-compliant Section 2 municipalities. That's why this is a leach case.
Explain to me again why this case is not controlled by Burson.
Because Burson set a rule that governed everyone the same way. There was no distinction between how it impacted all three of those governments. All of their charters were superseded by the rule. It's just that two of them were already in compliance and one was not. This is not about whether Metro Nashville is in compliance. The Act itself, on its face, treats non-compliant Nashville differently than non-compliant cities in Section 2. Leach says that's unconstitutional, and it would require this court to overrule Leach.
Ms. Bustle, if I could ask you to try to stay close to the microphone. We've got online folks, and I want to make sure they can hear everything.
Yes, thank you so much for the reminder.
And now that you've moved closer to the microphone, I have a question about the exemption clause argument. What if the General Assembly passed a law that set the size of the metropolitan county legislative bodies at a minimum of 50 members? Does that violate the exemption clause?
That's a great question, Your Honor. I do agree that is a harder question than the issue that's currently before you. The cap in the Constitution is 25. So what we do know from the exemption clause, both its plain language and its purpose, is that the General Assembly cannot set a cap below 25. So I would submit that is not a question that the court has to answer in this case.
But I would like for you to answer it for me, if you could.
Sure. I think the answer is that the General Assembly can't do that, and here's why.
That would violate the exemption clause.
It would violate the exemption clause. And I think it's very important to consider both the text of the exemption clause and the purpose of the exemption. So I want to walk through that because it really does sort of set the stage for the answer to your question. So the clause says any county organized under the consolidated government provisions of Article 11, Section 1 shall be exempt from having a county executive and a county legislative body as described in this paragraph. Let's put a pin in that language. It means a lot. So what is the contemporaneous meaning of exempt in 1977? Well, it means to be relieved from or free from. So to be exempt from having a county legislative body, as described in this paragraph, means exempt from the requirements in that paragraph. That includes a 25-member cap on the size of the body. Now, the state says Metro Nashville has a right to set a larger size, but the General Assembly isn't restricted from changing that. But the cap on legislative body size does not identify the General Assembly. It just says no county legislative body shall exceed 25 members, and the state concedes that that cap restricts the General Assembly.
I don't want to, if you need to finish the answer to that question, that's fine, but I would also like you to address the state's, what I take the state's primary argument to be before this court, which is that this just doesn't apply to Metro Nashville because the language in the exemption clause says any county organized under the consolidated government provisions in that final sentence of the exemption clause. So if you could also address that as you answer
That is
Justice
exactly
Tarwater's
where
question.
I was headed. That's exactly where I was headed. So the second argument that the state makes is that the exemption simply means Metro government's legislative bodies are not county legislative bodies as that term is used under the Constitution. And that's wrong for three distinct reasons. And I think this explanation will answer your question directly, Justice Tarwater. So first, that argument is not supported by the text.
But the text says any county.
The text
So how is that not supporting that argument?
The text says, exempt from having a county legislative, from having a county executive and a county legislative body as described in this paragraph. County executive is not described in that paragraph. It's not even mentioned outside of the exemption clause itself. County legislative body is described in that paragraph, including that requirement that it not be over 25 members. So the text doesn't support that argument. It actually would render, as described in this paragraph, meaningless. The early draft reports on local government that would ultimately become the text of the exemption, it would become the text of the entire section 1, also disprove this reading. I want to draw the court's attention to the Convention Journal that contains the early draft language, pages 486 and 490. Those drafts of the proposed exemption, they exempted metro governments in 2 separate sections. Section A does what you're describing. It exempts them from having a county executive and a county legislative body. But the exemption in Section J also included Section B of that report. And B contained all of those county legislative body requirements. That was always intended to be part of the exemption. So that Section B effectively became the requirements that were, quote, described in paragraph 2. So the state is also incorrect because their argument effectively merges the second and third types of county government. So those 1978 amendments restructured county government, creating 3 forms. And this is outlined in the court's decision in State ex rel Manor. First, you have default county government. That's Article 7 government, which is what this court has described it as. That government has those requirements in Section A and B of that draft report. Then you have consolidated governments. They're exempted from those requirements. And then you have alternate forms of government, which are governed by the statutes of the General Assembly. And it says that explicitly in the Constitution. To say the General Assembly can do whatever it wants to a metropolitan government's form of government effectively merges those last 2 types.
Could I go ahead, Justice Campbell?
Would you agree that a metropolitan government is not equivalent to a county?
I would not. No, there's no authority that when a metropolitan government consolidates its city and county functions, that it ceases to be a county. Davidson
Well,
County,
no, and that's a different question, and that was going to be my follow-up question. But I think there are 2 questions, right? Is a metropolitan government equivalent to a county? Are they the same thing? Or is the county just part of the newly formed metropolitan government? I would agree with you that the county doesn't cease to exist. The county remains, but you have a newly formed government. And it seems to me that if the metropolitan government is not the equivalent of the county, if you have a new government that is formed through consolidation, that the most sensible and textually sound reading of that last sentence of the exemption clause is just that it relieves the metropolitan government from having to have both a legislative body for the metropolitan government and a legislative body for the county. That would just be nonsensical, right? That would be duplicative to have 2 legislative bodies for the metropolitan government. Why isn't that the best reading of the final sentence of the exemption clause?
Because it renders the exemption meaningless. So it renders, first of all, it renders, as described in this paragraph, completely meaningless. And I think it completely ignores the proposed exemption that ultimately became the exemption.
Counsel, doesn't your argument rely primarily on negative inference from the actual language that's in the Constitution? You're saying the exemption says that it's not subject to the numerical limit that's on counties, and then the second section says there are other forms of county government that are regulated by the legislature. It seems to me that your argument under both provisions is that if it does not explicitly permit the legislature to enact legislation that's not inconsistent, to Justice Tarwater's question, that's not inconsistent with the constitutional provisions on counties, then the legislature cannot regulate that. Isn't that the negative inference that you are relying on?
Respectfully, Your Honor, it is not. We would submit the Constitution is not silent on this subject. The Constitution says metropolitan governments are exempt from having a county executive and having a county legislative body as described in this paragraph. That language must be given meaning. And I think it's also helpful to consider, why was the exemption even necessary in 1978? And I think this touches on both Justice Campbell and Justice Tarwater's questions. The constitutional delegates knew in 1977 that a consolidated government does not cease to be a county upon consolidation. And they knew that when the Constitution required something of a county, that would apply to Metro Nashville absent an exemption. Because what you see in the journals is tons of discussion of the need for an exemption to keep Metro Nashville or any local government that they extended the exemption to from having to hold a new referendum immediately after the convention to reaffirm their form of government. Well, Metro Nashville's form of government at the time was a 40-member council over that 25 mark. And so let me say that differently, because this is key. Because of the language in the exemption clause, Metro Nashville did not have to hold a new referendum after the convention to reaffirm its form of government. That wasn't because it said county and they're not a county. It was because of the exemption. And the discussion of the exemption and the need for the exemption makes that abundantly clear. Under McNabb, this court must ask how a reasonable reader would have understood that text at the time the exemption was enacted. And so to affirm the Court of Appeals, you must conclude that in 1978, the General Assembly could have completely disbanded Metro Nashville's council immediately after the convention. That is a necessary implication of the Court of Appeals holding, and that flies in the face of the text that would render the exemption completely meaningless. Its purpose was to keep Metro Nashville from having to hold a new referendum.
So could I?
I'm sorry. Go ahead.
Thank you, Chief Justice. I am having a bit of a catch here with your argument, and let me tell you what I mean by that. If the exemption clause prevents the General Assembly from reducing the size of the Council of Metro Government, and it also prevents the General Assembly from increasing the size of the Metropolitan Council, then exactly what is the role of state government in regulating local metropolitan governments?
It's abundant. Where the Constitution does not contain an exemption or an express prohibition, of course the General Assembly is free to regulate that.
They have broad regulatory powers over metropolitan governments, and isn't that true? And all counties and all local governments.
The General Assembly has broad regulatory powers, but not where the Constitution limits them. And the exemption clause was always intended to preclude Metro Nashville from having to go through that whole process again. What you have, you can keep. And so to affirm the Court of Appeals means the General Assembly could have passed this act 5 minutes after the constitutional exemption was adopted. And that defies the stated purpose of the exemption, and it frankly renders the exemption meaningless.
You would agree, wouldn't you, that there's nothing in the Constitution that prohibits the General Assembly from imposing a cap lower than the 25? Wouldn't you agree with that?
I don't. The exemption.
Well, point it to me. Tell us where that is.
It's in the exemption clause. The exemption clause says that metro governments are exempted from the requirements in paragraph 2.
But that doesn't say the General Assembly can't reduce the size of the council.
Well, the cap doesn't say that either, but the state concedes that the cap governs them. In fact, the sponsor believes he can't touch county legislative bodies at all because of the cap. And it doesn't speak to the General Assembly either. Neither mentions the General Assembly.
I'm sorry, Council, I realize your time's about to, but I wanted to probe one other area of your argument. And that's with regard to, I understand it's now Metro's position that not only Section 1B is moot, but also Section 1A is moot. Is that correct?
That is not correct. That is broader than our position. Our position is that 1A is moot as implemented through 1B. Again, 1A connects to every subsection that follows by virtue of the plain language, which is very different than the plain language in Section 2. That was intentional. So 1A as implemented through 1C, that has not been challenged here. And it's not moot. There were no local informer effect provisions in C. Same for D, same for E. Those provisions stand. We are simply asking the court to enjoin 1A as implemented through 1B because there is an inextricable connection between those provisions.
But Metro asked the trial court to dismiss its complaint based on mootness, correct?
Yes, because the complaint sought relief from 1A as implemented through 1B. Our request at summary judgment was never broader than that. I am out of time, but I will reserve my 7 minutes. Thank you so much.
Thank you, Your Honor, and may it please the court. Madeline Clark on behalf of the Appellees. In 2023, the General Assembly surveyed local governments around the country and determined that local councils function more effectively and efficiently when composed of fewer members. Accordingly, the General Assembly passed the act at issue. Section 1 limits the membership of every metropolitan council in the state to 20 voting members. Section 2 limits the membership of every municipal governing body in the state to 20 members. Metro Nashville now asks this court to create a Metro Nashville only exception. But each of Metro Nashville's arguments fails. First, the act does not violate the local legislation clause. The act applies the same size limitation to Metro Nashville that it applies to every other metropolitan council and municipal governing body in the state. Second, the act also does not violate the exemption clause. The exemption clause, at most, provides that metropolitan councils are free from the constitutional cap on legislative body size, not from statutory caps.
It says, doesn't it, Ms. Clark, that, quote, as described in this paragraph, isn't that what the exemption clause says? Shall be exempt from having a county executive and a county legislative body as described in this paragraph. How do you interpret those terms as described in this paragraph?
Yes, Your Honor. So best read, we do think the exemption clause relieves a county with a consolidated government from having to have both a legislative body and a metropolitan council. And even under that interpretation, we think as described in this paragraph does do work. So we think that the exemption clause, that language is clarifying that a county legislative body, the entity created by the Article 7 amendments in 1977, is a legislative body with the characteristics laid out in paragraph 2. So,
you don't think it has anything to do with the size of the council? The size of the council is described in the paragraph. So
it is described in the paragraph, but we think what the exemption clause is doing is it is saying, you know, the amendments to Article 7 create an Article 7 government where a county has to have a county executive and a county legislative body. Paragraph 2 then sets out all of the requirements and what the characteristics of this new legislative body. And then the exemption clause says consolidated governments do not have to have a county executive or this county legislative body as just described. But even under a reading where all of the exemption clause is doing is saying that metropolitan councils don't have to comply with those constitutional characteristics laid out in paragraph 2, that's all the exemption clause is doing. It is saying that these constitutional requirements do not apply to the Metropolitan Council. The exemption clause is not otherwise restricting the General Assembly's authority to impose those restrictions as a matter of its legislative authority.
Ms. Clark, I want to go to the local legislation clause, if we may, and I'd like to ask for your view of, I guess, where in the local legislation clause itself this transition provision exception, we'll just call it that for now, where is that, I guess, in the text of the local legislation clause? I realize that our precedents, support the notion that those sorts of provisions should not be subject to the local legislation clause, but I have a hard time, I think, rooting that in the text of the local legislation clause itself.
Your Honor, I think it emanates from the language, any act of the General Assembly, private or local, in form or effect. So when you have a law with a transition provision like this one, the specific provision might apply to only one county, but looking at the act as a whole, the act is applying the same substantive rule on every regulated government. So here, although 1B is applying specific transition provisions to Metropolitan Nashville, it is in service of the same general rule that is being applied to every Metropolitan Council in the state. And when that is—
But how do we not consider 1A and 1B together? To follow up on Justice Campbell's question, I had the same issue. Local in effect, to me, I'm not seeing an asterisk for a transitional provision in there. Looking at Section 1 as a whole, it says, Metro Nashville, you must have no more than X number of council members, and here's how you must reduce the size. I mean, it just says, Metro Nashville, looking at you when you consider the provision as a whole, and trying to ground our interpretation in the text of the local legislation provision. I just don't see the little asterisk that says it's okay if they're in a special situation. Metro Nashville's in its own special situation. That actually begs the question that it's crafted to address the particulars of Metro Nashville's situation. I'm not sure how to interpret the text of the Constitution consistent with your argument.
So I want to take my answer to your question in two parts. So first, your question implicates two separate provisions of the act at issue. It impacts 1A, which provides the general rule that all metropolitan councils must have a 20-member cap, and then 1B, which provides the specific mechanisms for Metro Nashville to come into compliance with that cap. So as to 1A, it is on its face a general rule, and it in application applies to every metropolitan council. And so under this court's precedent in Burson, that Metro Nashville is the only affected locality that has to take steps to come into compliance, doesn't render it local in form or effect, because the other two affected metropolitan councils have to maintain compliance.
Aren't you reading 1B out of existence, though? Because 1A, when you consider it with respect to Metro Nashville, 1A cannot, explicitly refers to the provisions below, and the one that applies to Metro Nashville is B. So it seems to me that your argument reads 1B out of the legislation.
We don't think our argument reads 1B out of the legislation. We think our argument gives, as further provided herein, the effect that the legislature intended it to have, which was that language just means this general rule applies consistent with the following. I think an example can make this clear that language is just—
I agree that that's consistent with the legislature's intent. I'm looking more at the language of the Constitution. I'm not sure that it's consistent with the language of the Constitution. That's what I would prefer you address. I do understand that there are other provisions that deal with the other metropolitan governments, but those provisions, 1A and 1B together, refer only to Metro Nashville.
So we think it's consistent with the Constitution because 1A and 1B are independent of each other, and 1A applies a general rule that applies to multiple metropolitan councils, and therefore, under the express language of the Constitution, is not local in form or effect. And we think 1B is also not local in form or effect because in the context of the entire act, it is a temporary measure to bring Metro Nashville into compliance with the general rule, and that is the way the court has interpreted the language of the local legislation clause in cases like State Ex Rel Manor. My friend on the other side mentioned Leach v. Wayne County, and I think that's actually a particularly helpful case for understanding transition provisions. The law at issue in that case had two aspects of it that were challenged by the plaintiffs. One was a transition provision that provided, I believe, that the county executive would continue, I think that the county executive and the county judge would both continue in office for a period of time, and that was going to be unique to Wayne County. But because it was temporary and only intended to bring Wayne County in line with a general statutory rule that would apply to every other county, the court held that was a transition provision. Whereas another aspect of the law provided a different rule permanently on Wayne County that applied to every other county.
And again, what constitutional language are you rooting your transition provision interpretation in?
It's the part of the local legislation clause that says any act of the General Assembly that is private and local in form or effect. We think that that language requires the court to look at the act as a whole and not one provision in isolation. But I will also say that even if 1B of this specific act is local in form or effect,
So what if the provision said, for a period of 5 years, metropolitan governments who have more than 40 members or more than 20 members have to reduce their council size? The General Assembly passed an act that said, for a period of 5 years, you have to do that. That's temporary. You're saying that that would comport with the local legislation clause because it's not indefinite?
I don't think it would comport with the local legislation clause because it needs to be a temporary, at least in this act, it is a temporary provision that at the expiration of that period puts the county in the same position as other regulated counties. So in your hypothetical, they would be reduced for 5 years, and then at the end of that 5 years, they wouldn't be subject to the same it's not in service of subjecting them to the same requirement as every other county. Were the rule otherwise, were the rule as Metro Nashville contends, their position is effectively that the local legislation clause prevents the General Assembly from enacting general legislation that could apply to a county with unique circumstances. And what the transition clause was doing here was trying to account for unique circumstances in one county to help it come into compliance with the general rule. But even if this court were to think that 1B is impermissible local legislation, that does not change that 1A is a general requirement that applies to all metropolitan councils, including Metro Nashville.
How significant is it, Ms. Clark, that this act, does contemplate implementation of this, in situations other than just Metro Nashville? I think that is something that perhaps distinguishes this, and I know we'll have another argument later about the airport authority case, but it's hard not to draw some distinctions between the two for purposes of this argument. But I think that is one thing that distinguishes this act from the Airport Authority Act is that the provisions in here that really contemplate how this is actually going to go into effect address multiple scenarios. There is a specific provision for the unique situation of Metro Nashville, but then you also have provisions that address others. And when you're looking at the act as a whole, it seems to me that is significant. And I'm just wondering what your thoughts are on that.
We do think that is significant and helpful, that looking at the act as a whole, it makes very clear that the entire act is in service of imposing the same general rule in Section 1 on all metropolitan councils and in Section 2 on all municipal governing bodies. This law applies one rule to 348 localities in the state.
Ms. Clark, we see statutes all the time that apply to counties within a certain population range, very narrow, sometimes 500 people or something. It's my understanding those do not run afoul of the locality clause in the Constitution, because more than one county could come into that same population in the future, and you don't have to have it sent to a referendum by the voters or 2/3 a vote of the legislative body. Is that correct?
That is correct, Your Honor.
So are you arguing here because there are 92 counties in this state without metro government, that when those counties may implement metro government, that it also, that's the reason that it takes it out of the local legislation clause?
We think that's another reason that the law does not violate the local legislation clause, is that it applies to any county that becomes a metropolitan government is subject to the cap. Any county that is currently a metropolitan government is subject to the cap. It covers the entire waterfront of metropolitan councils, present and future. I do want to return for a moment to how to interpret the act, because much of Metro Nashville's argument hinges on the contention that subsection 1 is not, as Metro Nashville puts it, self-executing. As you know, subsection 1 states the membership of a metropolitan council must not exceed 20 voting members, as further provided in the section. We think the best read of the statute is that it imposes a mandatory directive on all metropolitan councils, including Metro Nashville. Metro Nashville's contrary argument hinges entirely on the phrase "as further provided," but as discussed, that phrase just means consistent with the following. It just confirms that the obligation to comply with the membership cap in subsection A must be read harmoniously with the rest of section 1's provisions. I think an example can make this particularly clear. Say, being an enterprising lawyer, I decide to take up a side job babysitting, and being risk averse, I draw up a contract. Subsection 1 states the total cost for babysitting services is $100, as further provided in this section. Subsection B states payment is due when parents return home for the evening via Venmo. If I forget to collect payments that evening, no one would think the parents are excused from paying entirely. Likewise, if the application that I requested payment through is down, no one would think that the parents don't have to pay. This is because subsection 1B provides further details on the payment, but it does not condition that payment obligation. The act here works the same way. And it does not matter that even without the phrase "as further provided," the provisions in section 1 would have to be interpreted harmoniously with each other. It is not uncommon for legislatures to employ a belt and suspenders approach to cover the waterfront. And the surplusage canon is not an unyielding command. It is just a presumption that applies to the extent doing so would not violate the obvious intention of the General Assembly. That's this court's decision in Colonial Pipeline. In other words, as the U.S. Supreme Court put it in Rimini Street v. Oracle, the surplusage canon is simply a tool to help interpret a statute. And sometimes the best reading of the statute contains some redundancy. But the key is that the canon cannot be used to override the obvious intention of the act, which here, looking at section 1 and section 2 of the act as a whole, was to apply a cap on legislative bodies within the state.
Ms. Clark, I think earlier you indicated that your argument was that 1A and 1B are independent of each other. But yet then you also argued that we need to look at the statute as a whole to determine whether it violates the Home Rule Amendment or not. Aren't those two arguments inconsistent?
I don't think those two arguments are inconsistent. What we're arguing there is they are independent in the sense of 1B does not condition the obligation in 1A, but this court still needs to look at the statute as a whole when determining whether it violates the local legislation clause, meaning if the court just looked at 1B in isolation and ignored the rest of the statute, it would have before it a provision that applied only to Metro Nashville. But when the court takes a step back, it sees that that provision is part of a scheme applying the same rule to all statutes. So we think they are independent in the sense that 1B is not a condition on the mandate in 1A, but the court still needs to look at the statute as a whole to decide whether 1B would violate the local legislation clause.
Ms. Clark, could Metro still comply with this statute?
Yes, Metro still can comply with the statute. Metro Nashville can propose a charter amendment to its voters. Indeed, Metro Nashville asked this court for expedited argument, and it said in its motion that if this court were to affirm, it plans to propose a charter amendment to its voters. We think that the grant of authority in 1B4 is also still live and would allow the Metropolitan Council to do that, but the court doesn't need to look at that because Metro can propose a charter amendment, and as we understand it, plans to if this court affirms.
And if the amendment fails?
If the amendment fails, we might be back in litigation over what that means for the challenged law and the authority of Metro Nashville's council, but it does not render this case moot, nor does it bear on the local legislation clause challenge or the exemption clause challenge before this court.
My guess is you might well be back in litigation.
We don't know. We'll see.
Could the legislature have just enacted, Section 1A, just the regulation without specifying, how the Metro Council was to go about, or Metro Nashville was to go about complying?
Yes, absolutely. The Metropolitan Council, or the General Assembly could have just enacted subsection 1A. There is no obligation for the General Assembly to provide transition provisions, though as this court has said in State Ex Rel Manor v. Leach, it is often a legislative best practice to help affected municipalities come into compliance, but there is no obligation that the General Assembly do so.
And what would Metro, if the legislature had done that, had just enacted section, 1A without giving Metro Council any options for how to comply, it would have just been up to Metro Nashville's discretion to figure out how to go about this?
Yes, and
consistent with, any other applicable laws?
Yes, consistent with applicable law, yes.
Ms. Clark, I'm curious about this whole mootness thing. What's the state's position on the mootness argument?
We think that this case is still alive and still justiciable. We think that subsection 1A of the Act imposes a requirement on Metro Nashville's council that they have to comply with a membership cap. That is the cap that Metro Nashville challenges before this court. We have a live dispute over whether it's constitutional, so this case is not moot.
Okay, so 1B's moot, we can...
The provisions of 1B with timing no longer have effect, and so Metro's claims that were targeted to those timing provisions are moot.
Okay, and so if we buy Metro's argument that renders 1A moot, could we just dismiss the case and
if you
1A would still be on the books?
If you agree with Metro Nashville that 1A is conditioned on application of 1B, I'm still not sure as a technical matter that makes the case moot because the parties have a live dispute over what the statutory language means and whether it's constitutional. But if you agree with their framing of the case and you agree that their claims are moot, we would urge this court to nevertheless apply the public interest exception and resolve the constitutional claims in this case. There is, as my friend on the other side mentioned, there is an amendment to the law that has already been proposed, and so the issues of whether a law like this is constitutional, what the cap and the exemption, what the exemption clause means, how the local legislation clause applies to a law like this, those are all issues that are going to arise again in this context, and we think this is a good instance for the public interest exception.
Is the public interest exception still good law after Sokolowski?
We think there is tension between this court's precedents on the public interest exception and Sokolowski, and we would be fine with a ruling that the public interest exception is no longer good law, but to the extent it remains live, we think this case is a perfect application of it and fits within the circumstances.
Would you agree
How much
that,
of the, oh, I'm sorry.
No, go ahead.
How much of the mootness issue do we need to decide before, typically that sort of thing, we would have to grapple with that before we reach any kind of constitutional interpretation, wouldn't we?
This court has said
Unless we just, applied a sweeping mootness exception, then we have to grapple with that.
this court could apply a mootness exception and not address the issue that way. This court has said that justiciability, of which mootness is a part, is a threshold issue. And so in that sense, the court will have to grapple with the justiciability issue first. But if the court agrees with our interpretation of the statute that 1B and 1A are independent, then the mootness issue goes away and the court could proceed to the constitutional
Yeah, but we don't
issues.
get to that until, if we have to grapple with mootness first before we get to the interpretation, because typically we don't address a constitutional interpretation if the issue is moot. So, I mean, you're saying if you agree with our interpretation, you don't have to grapple with mootness. But in terms of logical analysis,
Right.
we have to grapple with mootness first.
The way that Metro Nashville has framed their mootness argument intermingles the statutory interpretation question with the justiciability question. My understanding of it is that their argument is that Section 1A applies to Metro Nashville only through Section 1B. And my understanding is their argument is that that is why their case is moot, because they argue it can only apply to them through 1B, and 1B's mechanisms were time limited and the times have passed.
So we can't decide the mootness issue unless we also decide the constitutional interpretation issue at the same time?
I don't think this court can resolve the mootness issue. Well, I think there's two ways of looking at it. I think because the parties have a live dispute over how to interpret the statute, it's difficult to conceive of this case as moot. But the way that Metro Nashville has framed the issue is the mootness question turns on how to interpret the statute. So the court would have to interpret the statute to resolve their mootness argument. At least that's how I understand it. In sum, nothing in the Constitution prohibits the act. The exemption clause at most excuses Metro Nashville's counsel from the requirements in Article 7, Section 1, Paragraph 2. The clause imposes no limitations on the General Assembly, leaving it free to impose a cap on Metro Nashville's counsel. And because the act imposing that cap imposes the exact same requirement on 347 other localities in the state, the act does not violate the local legislation clause. Holding otherwise would contradict decades of this court's precedent, including Burson. Finally, because the Act's membership cap applies to Metro Nashville independent of subsection B, Metro Nashville's challenge to the requirement remains live and justiciable. If the court has no further questions, I ask that the court affirm.
I'd like to talk about mootness first since the court finished there. So
That's probably a good place to start.
So Metro Nashville's position is not that 1A has no impact on Metro Nashville except through 1B. Our position is 1A, the statute does not currently force a reduction in the size of Metro Nashville's council except through 1B. We agree that that other provisions in the act would prevent Metro Nashville from having a council size larger than 20 if it were to amend its council size in the future. Those provisions have not been challenged. What has been challenged is 1A as implemented through 1B. And because of that inextricable connection in the language that connects those two provisions, those timelines are now expired. In fact, the state, until this level of the court process, the state had agreed that 1B was moot in its entirety.
Well, if there's a charter amendment, then there's no local legislation issue, right? Because there's local approval of reducing the council size.
If Metro Nashville agreed to reduce its council size, we would submit that is no longer mandated by this act because the state did not seek expedited review from the injunction that could have affected those timelines. So the mootness argument does turn on the plain language, just like the local legislation clause argument. And Justice Campbell, you're exactly right. This court has recently expressed concern about whether sort of the normal fay pals exceptions to mootness really continue, and we would submit the public interest exception in particular really makes no sense in the context that we have here. But if the court does interpret that language to create, we believe the court should interpret that language in 1A as implemented through 1B to create a local legislation problem. I want to address, this was sort of a recurring theme.
I'm sorry, let me interrupt you if I may for just a second then. So kind of the same question was asked of opposing counsel. So would your position be that if the General Assembly had simply adopted 1A, that there would be no violation of the local legislation?
If it had adopted one, right, Your Honor, and Section 2 of the Act establishes that, right? So, and I think this is an important distinction to make. The problem is not the cap under the local legislation clause. The problem is the cap and how they implement the cap for non-compliant Metro Nashville. They don't treat it the same way as to non-compliant cities. And that's what makes this a Leach case and not a Burson case. The act does not merely set a statewide cap in A. To find as such renders, as further provided in this section, completely meaningless. And the General Assembly is proposing legislation to fix that, to clarify that. As interpreted by the Court of Appeals, this act essentially sets the same rule 3 different times in Section 1, and then the same rule, but using totally different language in Section 2. That's not just a little redundancy. That renders half the act superfluous. That defies the principles of statutory interpretation.
Ms. Bussell, I would like to, you've mentioned what's going on across the street over here a couple of times about proposed legislation. Is that in this record?
It isn't in this record. That just happened last week, Your Honor. We merely mention that because that act would correct the local informer effect nature of this law.
And we're supposed to consider what they may or may not do over there?
I'm sorry, this is proposed legislation at the General Assembly.
I understand. Proposed legislation, and we're supposed to, how does that fit into, what weight should we give that in deciding this case?
It really just provides context to show that the sponsor of this act.
You just threw it in there.
I did just throw it in there,
Okay.
Your Honor. It was filed last week. It was filed last week.
And in fact, there's no legal authority for us to consider that at all, correct?
I don't think the court, I do not think it moves the needle on what the court is deciding. I do agree with that. We simply submit that it is consistent with Metro Nashville's interpretation and reading.
Well, but as a practical matter, legislators often introduce legislation if something's tied up in court as a backup to if they lose in court, right?
Right, and we would submit, Your Honor, that's exactly what they should do.
But if it's a backup, how does that impact what we do here?
And I'm not
why is it even relevant?
I'm not suggesting it does, Your Honor, but it is, we would submit that's exactly what the General Assembly should do to correct a law that is unconstitutional. The court should not rewrite that law to make it lawful.
Ms. Bussell, would this case be different if there were more than one non-compliant metropolitan government, consolidated government?
No, because Leach still says that.
What if there were 3?
That
Because you seem to be hanging your hat on this distinction, the way that the Act distinguishes between non-compliant consolidated governments and non-compliant municipalities.
Right.
But that wouldn't be a problem. Well, tell me if, in your view, that would be a problem if there were, multiple counties or, multiple governments falling into both of those buckets. Is it just the fact that there is only one non-compliant metropolitan government, and that is Metro Nashville here? Is that what makes this unconstitutional in your view?
I think if there were 2 non-compliant metropolitan governments, Leach would still govern. And so the key there is, are you setting a rule and treating...
And you're getting that only from Leach? Or, where is that 2, that 2 cap in the constitutional text? Why is 2 okay, but maybe 3 wouldn't? Why would 2 not be okay, but 3 might be? Where are you deriving that from the Constitution?
I don't know if 3 would be. There is some reference to that in the delegates' debates, but Leach very clearly says if the law applied to these 2 non-compliant, or treats these 2 cities differently, then it is a local legislation clause problem. Very briefly before, I want to mention transition provisions. Your Honor is right. That is not in the text. The state, however, isn't even willing to limit transition provisions to the case in which it arose. This was not a constitutional amendment. They are asking you not only to ignore the holding of Leach, which said those provisions that treated those cities differently, that's unconstitutional. It's not a transition provision. They want you to expand Leach completely outside the constitutional amendment context. And then finally, under the exemption clause, Metro Nashville had to be a county in 1977.
Ms. Bussell, you need to wrap up.
If it weren't a county in 1977, the exemption clause meant nothing and it would have been meaningless. So thank you. We ask you to reverse the Court of Appeals. I appreciate your time.
Thank you. Thank you both very much. Court will stand in recess.
All rise.